it was important for us in going through and revising the contract that the parties to the contract, which are the purchasers and sellers, of course, understood that this contract could be revised. And therefore, these pre-printed terms could be stricken out and changed. And that was not in the old contract. That type of language is not in the old contract. The issues that we had going through this were dealing with the law in Alabama, and I know you've all heard of the term caveat emptor, and that was one of the issues we were trying to deal with, which is a doctrine of law. And Alabama has come up with 3 exceptions to caveat emptor. In other words, it's a doctrine that says the buyer has the duty to determine whether or not the house is in the condition that they want it to be in at the time they purchased it. The exceptions to that are very narrow and limited exceptions. One of those is if there's a latent or hidden defect affecting health and safety. And that's health and safety that is imminent to the purchaser. It's not a potential problem that could occur in the future, but something that exists at the time. The other exception to caveat emptor is if there's a direct question asked of the agent or of the seller, a direct inquiry, as they say, such as, has the basement leaked or does the basement leak? That sort of direct inquiry. And the third is if there's a fiduciary duty. In other words, if the seller is a fiduciary or has a close relationship with the buyer, is there some presumed duty? So caveat emptor is a duty issue. Okay, and I want to get that clear because when we go through this contract, we're going to be talking about duty and disclaimers of reliance. The duty issue means caveat emptor, the duty on the buyer to determine the condition of the house, except if they make a specific inquiry, if there's a latent defect affecting health and safety, then the seller or the agent, if they know, have a duty to disclose that. So you see how that duty is shifting around. So we're not a pure caveat emptor state, we're one with exceptions, and those are the 3 primary exceptions of that. So in going through this, we look at what the duties of the agent are. And then you have the area of contract law, and that's where you see the disclaimer language in the contract. A lot of times in litigation, I see purchasers or sellers thinking that a real estate agent wears a lot of different hats. They think a real estate agent may be should be their lawyer, should be their engineer, should be their pest control inspector, all those sorts of things. So we want to make sure in the contract that the purchaser understands or has the ability or the opportunity to understand that that's not the case, that a realtor is simply someone who is facilitating the transaction to sell the house. So let's look at let's think caveat emptor. We want to get those terms out first, and disclaimer. In other words, you've got a duty under caveat emptor as a seller or real estate agent. If you know of a problem that's a latent defect that affects health and safety, you have a duty as a seller or realtor to disclose that. Or if you're asked a direct question, you as a realtor have a duty to answer honestly that question. Or if you're fiduciary, you have a duty to disclose it. So it's shifting that duty from the buyer over to those people, the seller or the realtor, and those 3 exceptions. Now the disclaimer language in a contract, though, trumps that. In other words, think of it this way. In order to have an obligation, such as, let's say, misrepresentation claim, you have to have a duty to make that representation, and you've had to breach that duty. In a fraud case, if a claim of fraud is a misrepresentation that someone relies on to their detriment. One of the elements of misrepresentation is reliance. If you don't rely on what you've been told, you can't be defrauded. I mean, that makes sense. So the disclaimer language in a contract trumps those duty exceptions. And so it's important to have these in the contract because we've always been asked this question, why is this in there? Well, first of all, we want to make sure that purchasers, the consumers, understand the limited roles of a real estate agent and is not relying on a real estate agent when they say, well, the real estate agent assured me this was a good house. Now that, which I hear a lot of time in litigation. So we want to make sure they understand that in the contract and that it's printed in there that I'm not relying on anything the realtor told me, that I have an obligation to inspect the property, okay, to inspect it by satisfaction.